Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Pragyansha Verma. She is going to speak on analyzing section 69 of the Bharatiya Nyay Sahita. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Pragyansha to commence with her lecture. Thank you.
Hello everyone. Today I am going to analyze section 69 of the Bharatiya Nyay Sahita 2023. The commencement of Bharatiya Nyay Sahita was on 1st July 2024. The aim of Bharatiya Nyay Sahita was to replace the then colonial law of Indian Penal Code 1860 to modernize and remove the outdated provisions, bringing it to the societal needs. The Bharatiya Nyay Sanhita introduced many new provisions. One of such provision was section 69. Section 69 defines deceitful means through sexual intercourses. As you can see, section 69 defines deceitful means through false promise to marriage, employment and promotion. It penalizes them with 10 years of punishment. Although before the commencement of Bharatiya Nyay Sanhita, such offences were dealt under section 375 of the Indian Penal Code but were not explicitly mentioned. The 7 circumstances under the Indian Penal Code were of 7 characteristics. Any one of the characteristics, if fulfilled, will amount to rape committed by a man over a woman. The second characteristic, which talks about the consent, was interpreted with the section 90 of the Indian Penal Code, which says a consent is said to be vitiated if it is obtained under a fear of injury or under a misconception of fact. The word misconception of fact was divided into 2 types, where the promise was attained on false deceit motion from the very inception, or where the promise was not able to be fulfilled due to unforeseen circumstances. It has been established by a category of judgments by the Supreme Court of India. One such judgment was Pramod Kumar versus the state of Maharashtra, where it was established that a person is said to commit rape upon a woman on false promise of marriage if the sexual intercourse was committed and if the sexual intercourse bear a direct nexus with the promise that was being given. As it can be seen, rape is a serious offence and is considered to be one of the most heinous kind. While a murderer destroys the physical frame of a person, rape is said to be destroying the physical, mental and psychological aspects of a woman. It shakes the very deep soul of a woman and leaves a scar permanent with her for the future. Such offences has to be dealt with sparingly, and thus the court, it lays a responsibility upon the court to distinguish whether the rape was committed or not, whether the complainant was aware of the obstacles going to arise of the marriages, whether the rape or the relationship ended due to unforeseen circumstances, or the relationship was started with the main motive to deceit. With the commencement of section 69 of the Bharatiya Nyay Sanhita, it has been surrounded by a number of obstacles and number of objections. A number of objections has been raised regarding its constitutional validity. As one of the Article 21, which is guaranteed by the founders of a constitution, and has been emphasized the right to privacy under the judgment of KES Puttaswamy versus Union of Indiana, where it emphasized the right of personal autonomy of a person. Criminalizing a personal intimate relationship on the basis of promise that was given in a personal sphere is somewhat need to be considered. Moving further, it has to be recognized that the act is considered to be gender biased towards men. It has to be considered neutralizing, and in a particular cases, consensual relationship need to be considered. The act is also being questioned on the malicious intent of the victim, through which complaint has been arised. all these number of obstacles arising with the constitutionality of the section 69, one such limitation that has raised following up concern all over India is whether its limitation on the transgenders, as it can be noticed in the decision of the High Court of Himachal Pradesh in the case of Bhupesh Thakkar versus State of Himachal Pradesh. It highlighted the gap that although BNS is declared the gender on the basis of men, women and giving identity to the transgender persons, it did not, it growed a complexities in application of these provisions under section 69, which plays an important role while governing the rights of transgender person. As it can be seen in the following case, it was filed by a transgender community person under section 69 and 18 clause D of the Transgender Persons Act. The High Court declared that the act covered only women and thus section does not place an and thus she cannot avail security under the said provision. Thus, in conclusion, these laws, although had been brought to modernize the criminal laws, remove the essence of the colonial period and bring in accordance with the societal changes, it lays a duty upon the legislature to bring the law so that they are not gender biased, they are not infringing the constitutional rights, and they are covering the various aspects as being defined in the current societal circumstances. They have to take into consideration the justice, equity and the good conscience and a nuanced and an inclusive legal framework, which is the need of the hour to address these mentioned lacunas in the present act and thus bring a more inclusive Indian criminal justice system. Thank you.
Pragyansha, thank you very much because you have touched a very new topic, BNS, which has just arrived, which is making its inroads. मतलब उस एक्ट को अभी बहुत ग्रो होना है and it was really nice to hear from you that the young students are now touching the BNS Act and trying to express their views on that. So it is really nice and I think keep on doing this. Thank you very much. A small token from us to you.